Hey there, this is Attorney Dan with Attorney Stephen Liu. We've been working on a couple of estate planning cases together over the last couple of months, and I thought I'd have Stephen here come and chat with us about estate planning and what he's experienced over his 20 years of practice. So thanks for joining us.
Yeah, my pleasure.
Yeah, so let's kind of get right into it. There's a certain way that certain ways that married couples can take title. And can you talk about the different ways that you've seen and the advantage of one way or the other?
Particularly for California, but also we can expand that to all community property states, which California is. We see, I would say, like in the early 2000s, a lot of married couples have held property as joint tenants, which is very normal. When one dies, it automatically transfers to the survivor. Great, right? It's called right of survivorship. But it doesn't actually account for some additional tax benefits for married couples. Like you and I, we can hold property as joint tenants.
With their spouses, not you and I together.
No. You and I can hold as joint tenants.
Yes, okay, yes, I understand.
That's what I'm saying.
Yes,
That's what I'm saying.
Yeah.
So anybody can hold joint tenants, right? Like I can hold joint tenancy with you.
Yeah.
But specifically for married couples are conferred an extra benefit as community property. So you can hold it with you and your spouse as community property with right of survivorship. So you get all the benefits of whoever dies, the survivor gets it, right? Just like joint tenancy. But in addition to that, as community property, only reserved for married couples, you get an additional tax benefit, right? Again, we can do a whole episode just on the tax benefit. But simply put, if you and I hold this joint tenancy, we only get half the tax benefit. Just because you own 50%, I own 50%. Upon our death, we get a new capital gains. We get a new basis. Okay. But as a married couple, how do I put it? You guys both own all of it. So upon the death of the first spouse, you get the full or double stepped up in basis and tax benefits. Maybe I'll just leave it at that. If you want to ask, yeah.
Just a little bit more. So essentially, if it's held as community property with a right of survivorship as a married couple, there's massive tax benefits compared to if they had held it as joint tenants with right of survivorship. So I would then say that for the people who are listening, if they're not sure how they hold title, especially like when we discussed this before, I think you said maybe in the early 2000s, this is how joint tenants with right of survivorship was kind of the most common way. I've seen it as recently as 2 months ago. They bought a house within the last, I would say, 3 years, and it was titled as joint tenancy with right of survivorship. So I would say for our listeners that if you're not sure, well, first, if you have a estate plan, go look at your documents if you still have it. But if you're not sure, reach out to your title company, reach out to any estate plan, so you can reach out to us, and we can check real quickly.
Yeah, we can pull the deed.
We can pull the deed in most places and check. And then, when we've done this before, right? Say, okay, we checked the title. All right, this is our recommendation. You probably want to move it to community property with right of survivorship, especially before someone passes away unexpectedly. And because once that bell rings, you can't unring it.
Exactly.
And you can't take advantage of the benefit.
Yeah, I think that's a good point. Is simply put, check if your house is held in joint tenancy or community property. You want to reach out to us, we can pull it. And then second, do it while you guys are both alive and well. Because once one passes, you actually give up that tax benefit.
Right.